Wrap up 2024 with a solution that helps you do more with less. Unwrap case management tools built for personal injury firms. With features like automated calendar reminders and all-in-one document management, CasePeer keeps your cases on track from start to finish. Unwrap the gift of CasePeer by December 31st and get a $250 gift card. Terms and conditions apply. Claim offer at www.casepeer.com.
Welcome to Brief Encounters and yet another episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner and a chair of the Securities Regulation and Litigation group at Armstrong, Teasdale. And in today's episode, we're taking a little bit of a departure from our usual point of view to focus on the presidential transition and its impact on the SEC. With me is our usual co-host, William Nelson. William, will you go ahead and introduce yourself?
Yeah, hi everybody. William Nelson, Director of Public Policy and Associate General Counsel at the Investment Advisor Association, and really excited for this episode. Kind of a lot's happened since our last episode.
That's right. And we are recording this episode just before Thanksgiving in November 2024, and it will be released right about December 4th of 2024. So we'll see in December how much of this we're getting right. But as I mentioned, today's episode is to focus on the presidential transition and its impact on the SEC. And we have a very special guest with us.
Yeah, absolutely. We're so excited and thrilled to have Sara Crovitz of the investment management practice at the law firm Stradley Ronon. She has more than 25 years of experience providing counsel on all aspects of investment company and investment advisor regulation. So Sara, we're so incredibly happy to have you. And feel free to add anything. I'm sure I did not do you justice.
So thank you both for having me on the show. I'm very excited to do this with you. So yeah, I'm a partner and co-chair at Stradley Ronon. I've been at Stradley for about 7 years now. And before I was at Stradley, I spent about 21 years at the Securities and Exchange Commission, most of that in the Division of Investment Management. And so I sort of have a bit of a perspective on sort of transitions at the SEC and how those go.
And you lived through several presidential transitions, including when the commission flipped politically as well.
And very many political flips back and forth. It's always interesting to see, the SEC's mission, obviously the three pieces of the mission, protecting investors, capital formation, and sort of market efficiency. And I think no matter who the administration is headed by, those are the mission pieces. It's just which ones get emphasized tends to shift a little bit depending on who's in power.
And I think that's exactly right. And, I always think an election year and the 6 months of a new administration is when those of us like you and I who are outside counsel at law firms find our jobs becoming far more policy focused and far more focused on prognosticating policy in a way that the other 3.5 years are not usually as a law firm practitioner.
I think that's right. I think people really want a sense of where things are going to go. The industry hates uncertainty, as it should. And so it's over. The transition times can be tough, but I think, we can talk about today a lot of the things that we would predict will happen. And I guess we'll see whether we're right or wrong in the next few months.
Yeah, absolutely, Sara. So I guess just, to start us out, I was wondering if you could just kind of chat a little bit about, now that we've had this presidential transition, what do you see happening with the SEC?
So I'll start. I think we can start with maybe sort of rulemaking and where I think that's going, and maybe then talk a little bit about guidance. And I know, Valerie, something you're interested in as well as me is sort of the enforcement division and where they go and what they're going to be doing. And maybe we'll do it that way. I think on rulemaking, it's pretty clear if you look at sort of the rulemaking proposals that have gone through and then some of the ones that have gone through and are scheduled to be reproposed. It's pretty clear if you look at those rulemakings that the Republican commissioners dissented in the vast majority, if not all of them. And so I think you'll not likely see a lot of the rules going forward. And what I'm talking about there is, rules like anything with swing pricing beyond sort of the monthly import reporting that was adopted in August. There's no way that will go through. Commissioner Peirce's dissent called that less a series of regulatory initiatives than an essay on Greek tragedy. So I don't think we'll see that go forward. The fund and advisor ESG rule, I also don't think we'll see go forward. while I think that and we can talk more about this later, while I think there still will be a clear focus on ESG sort of washing, I don't think that the commission is likely to go forward with prescriptive sort of disclosure rules around ESG. Predictive data, there's no way, I don't think that one goes forward. Again, Commissioner Peirce called that one a mirror reflecting the commission's distorted thinking. So I don't really see that one moving forward. Similarly, outsourcing for advisors, I don't see that rule moving forward under the new administration. But I don't know what you guys think about the cybersecurity rule. It seems odd to me that that fund advisor one is the only one that hasn't been adopted. And yet at the same time, I think there were concerns expressed by the Republican commissioners with regard to the other sort of companion rulemakings there. So that one I don't have a clear beat on. I don't know. Do you guys have a view?
Yeah, I'm happy to take the first crack at that one. We were a little bit surprised as well, especially when the SEC did come out with the final rule for Regulation SP, which is the SEC's data privacy rule. We always assume those would likely be paired together, because obviously data privacy, cybersecurity generally are both housed under this larger rubric of information security. So I think we were a little bit surprised not to see that because, again, I think that cybersecurity, even though, you definitely have differing views, it seems to be a pretty bipartisan, keeping everyone's data safe. But I don't know, Valerie, if you had any thoughts on that one.
I was surprised as well, especially because the investment advisor and investment company cybersecurity and vendor management rulemaking was essentially reopened with Reg SP. So I expected more coordination. I do think Reg SP was easier to finish, and that's why the staff may have decided to move ahead with that as a recommendation. I think the tough one in the investment advisor cybersecurity, and obviously that includes investment company, I think the tough thing in that proposal is that it has that entire vendor management framework embedded in it, which is very prescriptive, particularly for smaller firms. I think if that had been two different rule proposals, I could have seen the cybersecurity piece move forward, but maybe not the vendor management piece. The other issue on the IA cybersecurity rule was some of the notification requirements and updating on the ADV were verging on the onerous, particularly for smaller firms, but also not very well thought out in terms of where a registrant's priorities would be in the middle of a breach. And I think that too required more thinking. So I think that's why in the end, Reg SP moved forward. It was more straightforward, whereas the IA cybersecurity rule that had the breach notification piece and the vendor management piece all embedded in, I think those just were taking longer to unpack. It would be interesting to see if the staff made a recommendation on only a slice of that rule to at least get it through before December, but that's anyone's guess at this point.
Yeah, no, I think you're right. And I mean, it was interesting to me. I think there were concerns around the data breach notification provisions in the companion releases, but those did go through. And so again, I was sort of like, well, why? I'm not sure why this one didn't, but maybe you're right. Maybe it was the better management piece of it and sort of just the timing that impacted them.
And, we do have a history of large Advisors Act rules going through right at the end of a chair's term. And I'm thinking, of course, of the marketing rule, which was a very all-encompassing rule that was changed quite a bit from proposal to final, but it still went through right as Chair Clayton was leaving. I think it was on his next to last day that the open meeting occurred and the rule was adopted. So that could still potentially happen with parts of the cybersecurity rule. I just don't know if the entire package would go through.
Yeah, that would be an interesting move on their part to try and get something through.
Although it is the only one that I think has a small chance of being finished.
Agreed.
I don't think any of the others are, PDA is dead in the water for now, as are several of the other proposals you've brought up, Sara. I almost hate to bring it up, though, but what do we think about custody?
So custody, I don't think it will go through in its current form.
100% agreed.
But could they do something on custody? I mean, I think we would all agree that the current custody rule is a bit unmanageable. Could they do something to make it better and not sort of what the proposal was before? I could see the new administration perhaps going down that path. It would depend on how many other priorities they have, though, and whether there'll be room on the staff's calendar to work on that, because it would be a very different proposal, and then room on the commissioner's calendar to take that up.
And I think to your point, Sarah, should a Republican SEC take up custody again, it would be significantly different in that the entire crypto piece of the current proposal for custody and safeguards would be removed.
Yeah, and I think obviously with crypto, that's another area where I think we will see, if not rulemaking, potentially legislation to address that space moving forward. It's quite clear that the new administration has an interest in moving that forward, and a little less standing in the way of it moving forward than we've seen in the last few years.
Yeah, no, and I think that's definitely all spot on. One question I had, and I'd love for both of you to weigh in, is that, I know we've talked a lot about the outstanding rule proposals, but do either of you see any of the recently adopted rules? Obviously they're finalized, but do we see a new administration maybe going back and either modifying or repealing those? And I'm thinking specifically of, maybe the anti-money laundering rule for advisors, fund names rule, potentially the money market fund liquidity, or even, Form PF. I'm just curious as to if you see any type of maybe modifications or even repealing of some of those final rules.
So, I mean, it's possible. The thing that I found very interesting, and we didn't talk about proxy advisory firms, I do think there'll be some kind of rulemaking or legislative attempt to address the regulation of those. But the piece that came out from the Fifth and Sixth Circuit split decisions there, where the Fifth Circuit basically said that the Gensler administration did not have authority and was outside its authority in going and rolling back, trying to rescind pieces of the 2020 Clayton rulemaking, right? So I think that sets up a, standard by which the SEC would have to live if it were to try to roll back or, redo rulemaking very soon after rules had just come out. And so I think that will be, there's some impediment. I think they still probably can do rulemaking in those areas, but I think they will have to justify quite clearly why they're taking a different tack quite soon after the other rules were out.
Yeah, no, I think, Sarah, that's a great point. And it's interesting because I think there was a lot of support behind some of the recent Supreme Court decisions, which, did remove that agency deference going forward. But now you have the same issue of deregulation, is that the court can, kind of look at it fresh and say, hey, SEC, have you really provided that factual basis and that, really thoughtful reasoning why you are reverting to a previous position or modifying it?
And is the position that you're taking really consistent with the statutory wording and the authority that Congress gave the agency? There'll be obviously a lot less deference to taking positions that might be a little bit on the edge, no matter who the political party is and which way they're trying to move the rulemaking.
Exactly.
Sarah, is it fair to say at this point, as a result of really the last 2 years of both litigation outcomes and just general rulemaking difficulties, is it fair to say that at this point, SEC rulemaking will likely move much more slowly than it has in recent years and be chilled to some extent?
Fair to some degree. I mean, I think it really does depend on what kind of rulemaking they're trying to do. I mean, I think I sort of think back at my time at the SEC and different phases where there would be some very bread and butter rulemaking that, the division would want to get through. And so I think very bread and butter rulemaking where there's an area and a hole in the regulation or something, right? Maybe that can still go through and, it might be a little slower, but can still go through. I do take your point that anything that's trying to be a little more flexible, I guess, with the statutory wording is going to be definitely slower and, there'll be more risk associated with it and more questioning inside the agency.
Now, that makes a lot of sense, Sarah. So tell me a little bit, can you give us a sense of how things evolve during a transition period for rulemaking staff? Is it sometimes fully pencils down, Is it rescoping certain rulemaking objectives? Like, how does that work, or does it really depend administration to administration?
Well, I think probably right now, as we discussed before, unless there's some final push to try and get something out before this administration ends, I mean, I think it's likely that the current staff is sort of getting ready briefing books for the new administration and sort of thinking through the agenda that the staff would suggest, not knowing exactly who the chair is going to be and sort of thinking about what priorities they think are going to be important ones. So I think once the chair is announced, people have a better sense of who the chair is and what the chair's priorities are, those briefing books will be a little more targeted. Of course, you also have, at this point, the industry starting to weigh in as well with the commission with requests. When the new chair comes in, I'm sure that chair will get several letters from, including probably from the IAA with sort of here's what we've been thinking about. This is what's important to our industry. Here are some suggestions. And I think those are really great. I think it's really actually quite helpful for the new administration to hear of those. So I think we'll be seeing a lot of that, and that may, depending on who the chair is, have some influence on sort of the policy perspectives going forward. And then, it will take a while, most likely, for the new chair to put in the division heads. I don't suspect that many who are there now will stay. So the new chair will want to put in his or her own sort of senior staff people, and that takes a while. So you'll have some transition time where some of the divisions may not have sort of a top person or have somebody in an acting role. So that can also slow things down.
And the shift in division heads is very much par for the course for transition time. There's nothing unusual about that.
Absolutely. And I will say it is not always easy to find someone to take those roles on. You have to be a certain person at a certain point in your career to want to go to the SEC for, 2, 3, 4 years. For people who are out in the industry, it's a huge pay cut usually. And depending on who the chair is and what the priorities are for the commission at the time, that person may or may not be able to get their own personal agenda addressed during that time. And so it can be kind of difficult to find the right person for the job. So that also can add some time to the transition.
Yeah, that definitely all makes sense. One question, Sarah, I had, I know we've talked about the rulemaking space, but, one thing we've heard is that there's optimism in this new administration that since there'll be potentially less focus on rulemaking, there'll be more focus on providing more guidance and interpretive guidance to the industry. So I didn't know if you wanted to talk a little bit about that and maybe what you see coming out of this new administration.
Absolutely. I definitely agree that there should be some hopefully very helpful guidance forthcoming. One area that I think I'm going to say likely, I'm going to optimistically say we're likely to see ETF share class relief sometime maybe in 2025. I think you see both that Project 2025 endorsed a broader use of the SEC. So this would be exemptive relief to allow mutual funds to have an ETF share class or vice versa, the ETF to have a mutual fund share class. Perhaps some of the applications have asked for that. And when you look at Project 2025, they definitely endorse a broader use of exemptive authority. And there's also a white paper from some of the trade groups, chambers, and a couple of others, also encouraging broader use of exemptive authority and specifically citing to the ETF share class relief. There are, I think, over 30 applications now in for ETF share class relief. And so I think that is guidance that I would very much like to see the SEC take up. I do think we're much more likely now to see permanent relief for independent directors of funds to determine whether or not an in-person meeting is an appropriate use of their meeting time. There are certain things that have to be approved now in person under the rules and the statute, and I think we'll see a way for the SEC to move forward with guidance that makes that flexibility and gives that discretion to the board. I think there may be more support for some relief for the closed-end fund industry, which has definitely faced some headwinds with activists in recent years. There are some legislative fixes out there, like the Increasing Investor Opportunities Act, which passed the House on a bipartisan effort last spring. So I think we may see some support in that area. And then finally, it's a little esoteric maybe for your listenership, but acquire fund fees and expenses, which is a disclosure item for funds which has definitely impacted sort of disclosure for funds and certainly impacted the business development company industry, because investments in BDCs impact the fee table and what it looks like your expenses are when you're making investments. And so that has been an issue for years. And that may be one that we finally see some relief for. Commissioner Peirce included a statement on AFFE in one of the rulemakings, in the tailored shareholder report rulemaking. So that's a possible area for guidance as well. Valerie, are there any other guidance pieces that you see coming?
I do, particularly in two rules that came out during the first Trump administration that I think a lot of us sometimes forget were Trump era rules. I think both Reg BI and the marketing rule will have additional guidance. I could see with Reg BI a slimming down of the guidance that came out during the Gensler tenure and just a more of a back to basics approach to Reg BI, who, as we all remember, Reg BI came out, was adopted in 2019 and was implemented in 2020 when Clayton was chair. And I do think it will continue to be enforced. There's been quite a few Reg BI enforcement cases in recent months, both by the SEC and by FINRA, but I think there's going to be a return to the focus of the rule, which was really the issue of conflicts and disclosure, and perhaps a little bit less of an intense focus on the care obligation.
That's a great point. And I agree with you on the marketing rule as well, which has really been, the marketing rule came out. It was obviously an enormous undertaking to try to codify, years and years of sort of no action relief and pieces of lore from here and there. And it left a lot of open questions. And the staff really has not been hugely willing to answer any of those questions. So I do think you're absolutely right. That could be an area for additional guidance as well.
No, I think that's right, Sarah, especially because both Reg BI on the brokerage side and the marketing rule on the advisor side both have a large impact on retail investors, and both giving them additional disclosure, but also additional perspective to make decisions.
Those are all great points. And I think the industry is, really looking forward, hopefully, to more guidance and interpretive relief on, some of these more tricky rules and issues that you and Sarah talked about. But now, I would love to switch gears, something near and dear, I know, to your heart, Valerie, but also Sarah, kind of how you see the enforcement function of the SEC in a new administration. Do you think there'll be, maybe a lighter touch in certain areas? One thing we have heard, potentially much more of a focus on, cases with actual investor harm, fraudulent intent. I would love to get your views on that.
Yeah, I think we'll certainly see an end to the off-channel cases. I think we saw an extremely strongly worded dissent from Commissioners Peirce and Uyeda recently on one of those cases. So I think that we will see an end to that sort of money tree for the SEC. I think there are areas, though, where enforcement will continue. Exactly to your point, I think we will continue to see cases where the SEC thinks there's an impact on particularly retail investors. I do think that we will continue to see sort of ESG and AI washing, kind of greenwashing and AI washing cases. I think those will continue. I think we'll see less focus on sort of the private funds and private capital formation cases that would impact that, because I think that the Commission under this administration, like the Clayton administration, will be interested in finding ways to allow retail investors some access to alternative investments. So I think we will see less of a focus. Obviously, if there's, again, to your point, if there's fraud, if there's really terrible disclosure, in a private fund, I'm not saying we won't see those cases, but I think there'll be less of an emphasis on sort of going after, private equity or, footfalls or other areas like that. And Valerie, I think you talked about duty of care on the broker-dealer side. We've seen in the last few years, and this really came out of the 2019 interpretive release that the SEC did for investment advisors on the fiduciary duty as part of the Reg BI sort of package. We've seen an increased use of duty of care, or an increased focus by enforcement on duty of care cases, which really you didn't see those cases coming out of the commission almost never prior to 2019. And those are tough cases, right? I mean, duty of care is really, when you look at a lot of the cases that have been brought, it very much feels like 2020 hindsight, looking back and saying, well, if I were the advisor in that situation, I wouldn't have done this, so it must be a duty of care violation. And so I think that's a troubling pattern. But I also think, from just a policy perspective, it may be difficult to let go of that tool now that that tool is sort of out of the bag and there have been duty of care cases, because I think, again, sort of depending on what you think an advisor should do, it can be pretty tempting to bring a duty of care case in those instances where you just don't like the way they've been doing their business. So it will be very interesting to see whether those cases continue or not.
I think you're exactly right, Sarah. And what's really interesting to me about Advisors Act duty of care cases is how much I think they're going to get influenced by how Reg BI's care obligation is enforced, because those two cannot stand in separate silos. We see it quite a bit on the exam level, where there's far more sampling and quarterbacking of trading and recommendations for investment advisors now during the exam phase, which tells me that a good bit of the Reg BI care obligation checklist has also been ported over to Advisors Act exams. So, for example, investment advisor registrants are getting asked increasingly about the concept of reasonably available alternatives, which is very much a Reg BI care obligation concept, but getting pulled over to Advisors Act duty of care. I would prefer a lot of these questions stay at the exam level as opposed to getting pushed into the enforcement realm, because to your point, there's a lot of Monday morning quarterbacking and benefit of hindsight enforcement occurring.
Absolutely agree.
So we do have to talk about crypto a little bit, because I think that is where we're going to see some of the more sweeping changes. But that's, of course, not just at the regulatory or guidance level, but also potentially at the legislative level.
I do think it probably will end up legislative. I mean, you have the sort of CFTC, SEC jockeying for authority there. So it may be something that Congress has to solve. I mean, is this finally the era where the push for SEC and CFTC merging actually happens? That has been tried many times in the past. And I think the fact that there are different oversight committees in Congress who themselves are sort of jockeying for authority has certainly stymied that in the past. But I do wonder if this isn't the administration under which we see a merged agency, which would help them address the crypto, because then it would be in one house.
That's exactly right. What I find really interesting too is there's a renewed interest by states in crypto. And I'm thinking, of course, of the lawsuit that was recently filed by several state AGs against the SEC, calling the SEC's authority to oversee crypto as extensively as it has into question. So there's also going to be that turf war element, not just SEC and CFTC when it comes to crypto, but also where do the states fit in?
Yeah, no, and I think that's absolutely right, Valerie. I think there's just going to be so many questions. As Sarah mentioned, do we ultimately see some type of joint rulemaking? Because I know that is a big question about where the jurisdiction for crypto should lie, whether it's a security, whether it's a commodity, all those discussions going on right now. And then, Valerie, to your specific point, where do the states fit in, and how does, issues like preemption fit in there as well?
Well, Sarah and William, we've had a really robust discussion and have hit on a lot of SEC-related topics during this time of transition in Washington. We're going to wrap up soon, but before we do, there's obviously other transition topics that are either with regulators closely adjacent to the SEC in terms of impact on our industry, or are just larger government transition points that will affect the SEC. So I'm going to kick it off. with the FinCEN rule that now includes investment advisors, where the implementation date will be in just over a year. I think that rule is here to stay, largely because it was a bipartisan rule. But in contrast, William, I was hoping you could talk a little bit about the Department of Labor fiduciary, is it 4.0 at this point, effort?
Yeah, unbelievably, it is DOL Fiduciary 4.0, and I don't see a 5.0. And I definitely see the 4.0 that's currently being stayed in litigation. I just don't see the new administration defending it, but I also don't see them, even if it is ultimately, either if it's kept by the courts, it will, ultimately be repealed, or if the courts ultimately overturn the rule, then the new DOL will just not propose another DOL rule. So I do think that as of now, the DOL fiduciary is no more.
And Sara, any other topics we should touch on briefly before we wrap up?
I mean, the only other one I would touch on very lightly is sort of the general federal government and what's going to happen more generally from the Trump administration with the federal government. I mean, he's made plans now to have this Department of Government Efficiency led by Elon Musk and Vivek Ramaswamy. And so I think we will likely see, some measures of cutting or efficiency being imposed upon agencies, and the SEC, likely will face some of those initiatives as well. And whether that looks like, in the past we have seen, for example, suggestions that for every rule that's required, you have to repeal 2 rules or other kinds of initiatives. I think we will see some kind of impact there.
Well, thank you both for such a robust discussion. We did record this on November 18th, so by the time the episode gets released on December 4th, more may have happened. And then we have one more episode left in 2024, which William and I will be recording in early December. Thank you again to both of you for such a great discussion, and I look forward to next time.
This episode of Brief Encounters was brought to you in part by our sponsor, CasePeer. Learn more about CasePeer in the description of this episode.